So I think we can continue now with the very last presentation, and just afterwards we will continue with the discussion part of this second plenary. And I would like to invite Professor Séverine Dusollier to give her presentation. Séverine Dusollier is Professor of Intellectual Property at the SciencesPo University Paris. From year 2006 to year 2014, she has been a professor in the University of Namur, where she taught intellectual property, IT law, property, competition law, and media law. Professor Séverine Dusollier is recognized as an academic expert of copyright and IP. She has carried out research for the Belgian government, World Intellectual Property Organization, the Council of Europe, UNESCO, the European Commission, and Parliament. So the floor is yours, please.
Thank you very much, and thanks for the invitation to this very interesting discussion about exceptions. Yesterday evening, we were joking with Valerie-Laure. We said that we could make it into a duo today because we would certainly say things that would be in line with each other. And actually, we should have done that because you will see that actually we have similar proposals. And we could also have made a trio with Thomas, because I think that the three of us are really on the same thinking here. So maybe you can just let us do the review of copyright exception, and we will do something that would be perfectly balanced and effective and everything. Okay, having said that, I should also continue on what Thomas said at the beginning, is that as academics, we have the luxury of being able to dream and to maybe not be bound by realism sometimes. So what I will propose, or what I will explore with you, I know that to some extent it might not be seen as realistic, but there are also some ideas and some ideals also that could be maybe the substance of which could be taken as some guiding principle. So I'm completely aware that what I will propose might seem in some cases maybe too far-reaching or too idealistic. So the outline of what I will be doing is actually I will be proposing a methodology to review the copyright exceptions around 5 different lines: the revision of economic rights, the simplification and limitation reduction of the list of Article 5, a principle of uniform exception throughout the directive that has not been addressed so far, I think, an objective-based approach or a purposive approach, as Thomas has said. Actually, I will join him in that direction, even though I think we will do it a bit differently, and also addressing the cross-border issue. So I start with the need to revise economic rights, because I think that we have problems with exceptions also because we have defined economic rights in a too broad way and also in a too much technical way. And it's valid for reproduction right and communication to the public. First, to the reproduction, as reproduction is now defined as covering any act of technical fixation. Any use online is a reproduction, so any use offline is potentially a copyright infringement. And this is also true for communication, where transmission and making available is now happening anytime that you want to do something on the internet. I don't mean that it shouldn't be covered by copyright, but we should find a way, I think, to define economic rights that would maybe alleviate the problems for copyright exception, especially where actually you have some uses that would never have been thought of justifying copyright exception for the simple motive that they would not have been considered as copyright infringement, but because of the digital evolution, they are now implying acts of reproduction and acts of making available. And I will give you 2 examples: the text and data mining debate. instinctively, I think that extended data mining should not be even concerned with copyright. To some extent, it depends on what is done by text and data mining, but if it's just the fact that you analyze the ideas and the facts and the content of copyrighted works, then I think it should not be an infringement. But it became an infringement for the simple reason that when you do digital text and data mining, you are doing multiple acts of copies, so you need something to get out of that consideration. And I think that we took a wrong path here that finally forces us to address some new exception where we should avoid it. The other example I will give you is about an existing exception. It's the on-site consultation in libraries, and it concerns the making available. This is something that has happened within the premises of libraries for ages, you know. Librarians make you available the content of the library. This is what libraries are for. But because you use a device to do it, a dedicated terminal to do it, then it is qualified as a making available. And maybe we could also have a definition of making available that would make those acts that technically are acts of making available, not copyright infringement, because they are not for the purpose of making an infringement to copyright. They are acts that are bound with the purpose of the institution, and they are not on their own aimed at exploiting a copyrighted work. So this would be a first step, and how to do that. Actually, this is a bit outside of the topic of today, so I will be very quick in it. But I think that we should more focus on exploitation of work. We should not be obsessed by the technical definition of acts of use, but maybe look at the purpose of uses and having maybe an economic approach and thinking of infringement in relation to function of copyright and not as technical accidents that will occur during the use of a work. In other IP rights, like in patent, like in trademark, the notion of exclusive rights of economic rights is more related to the function of the right and to this ultimate purpose and to an economic approach. And we don't have that in copyright. We start with the exclusive rights that are defined as a means to a purpose, but due to the digital evolution, those economic rights have now become the ends in themselves. And this is, I think, a mistake that we should correct. I don't say that the copyright review is the right opportunity to do that, because I know that actually is maybe a bit too late for that. We should also think that ancillary acts of reproduction, so acts of reproduction that occur simply because you have a making available or another type of use that actually technically necessitate reproduction, should not even raise question. They should be authorized, they should not be considered as specific acts of copyright infringement. So this is for the first part. We could not consider exception without also looking to economic rights. And there was a debate yesterday, I remember that it was Jonathan who said that in some cases, making something as an exception would actually obliterate the question as whether there is an infringement in the first place. And this is something that we should also leave as free spaces in copyright. So some acts of use will not be infringement at all. So we should not even think of covering them by an exception. So this is for the first step of my recipe for exceptions. The second step, and I will rejoice what Valerie-Laure has said, I think we should simplify the list of Article 5 of the directive. We should harmonize and make exception mandatory only for exceptions that have an effect on internal market, so they have a cross-border dimension. But I think that it's not only a matter of cross-border effect. We should also intervene where the exception is related to a fundamental right, because we have the Charter of Fundamental Freedoms, and have a European public interest. I give you one example. It's the example of libraries. The use, the exception for the specific acts of reproduction within libraries. In itself, it doesn't have any cross-border effect. This is an act of reproduction that happens actually on the site of libraries, and usually those libraries are just located in one country, and they preserve their collection of their, the collection of their library. But we have a strong policy commitment at the European level towards the digital library, towards the making available of content of library online. I don't mean that this justifies that we should cover everything with an exception, but I just mean that you have here a strong European policy, public policy that is in place, and that could justify that some acts of use by libraries should be made mandatory and harmonized. Also because it could have an incidental cross-border effect if we are developing a thing like Europeana. If you give different conditions for libraries, member state by member states, to digitize their content, there, what will be available on Europeana might be also fragmented, because the libraries who will have the most possibility to digitize under their exception will give more content online than the others. I don't say that the making available online should be covered by an exception, but it will depend also of the content that is possible to preserve. So I think that we should not focus too much on the cross-border effect, because it doesn't it's not the only justification for European interventions. And I would leave other exceptions to the competence of member states. I would agree with Valerie-Laure that some exemption might stay within the competence of member states, with no harmonization, with no mandatory character, because actually they are of minimal significance. So if I make that exercise, and it's only just one attempt, you know, we might disagree. If you take the list of Article 5, I would keep, of course, the temporary acts of reproduction. I would keep in 5.2 the private copy reprography exception, the specific acts of reproduction for libraries, ephemeral recordings of work made by broadcasting organization. It is in Bern, so we could also keep it here, but you know, we could discuss that. I think it doesn't have a lot of importance. The reproduction of broadcasts made by social institutions, I don't think it's a matter for European harmonization. And in Article 5.3, the illustration for teaching and scientific research is important. The use for the benefit of people with a disability, the reporting of current events, the quotations. But then you could delete a lot of things, you know, the use of political speeches, the use during religious celebrations, the incidental inclusion of a work, that could be left to states. The parody exception could be left here. The other thing would get out. Actually, you will see that we come back to the list that was in the first proposal for a directive back in 1997, except for the quotation, for the parody exception. So it's really closer to the first list that the member states discussed. The difference is at the time that list was exhaustive. State could not keep other exceptions than those that were in that list. But my proposal would be that this would be the list of mandatory and harmonized exceptions, and the rest would be at the discretion of the member states. And then, actually, as Valerie-Laure, I would make a new paragraph out of Article 5.3.0 by just, sorry, when I put it in blue, it doesn't really work. So I would also delete some parts of it, but I would agree that member states can authorize some other use in certain other cases, provided that they do not affect the free circulation of goods and services within the community and without prejudice to the other exceptions and limitations. So actually it will not be a grandfather clause for cases of minor importance and for analog use, but it will be a sort of general mandate to the member states to keep some competence for other types of exceptions. Then one point that seems important to me and was not really addressed before is the fact that we need uniform exceptions. For the moment, the exceptions differ for copyrighted works and related right subject matter for databases, whether they are protected by copyright or sui generis right, and for software. You have different systems of exception, and it's not harmonized throughout the acquis communautaire, and I think this is a big problem for many reasons. First, because you have strange decisions like the ECJ decision in the Ryanair case last January that says that one limitation in database is only valid if this database is protected by a sui generis right. If it's protected by other thing, then the use that was protected is an exception, has no value anymore. And I think it is a wrong decision. I think that if you see that some interests of the users are worth protecting by an exception, that interest should be protected, whatever the legal framework applicable. Then you have, and this is more worrisome, I think, you have the evolution of the case law of the Court of Justice from the BSA case to the Nintendo case last year, where software is split into different objects. The object of a computer program is actually protected by different rights. Only the code is protected by copyright in computer program, and the rest will be protected by copyright, the droit commun, said the court, the common law copyright, but it refers to another thing. And so it means that for the same object in trade, you will have different exceptions applicable, whether you have you want to enforce your copyright in the code, or whether you enforce your copyright in the visual interface or in the images, for instance, produced by the software. The Nintendo case is very clear in that regard. It concerns video games, and they said that outside of the code, everything else in the video game is protected by the Directive 2001/29. And so it means that the matter of exception is really a difficult issue. For instance, we have had a decision very recently in Belgium where the question was whether the public lending was applicable to video games. If you apply the software directive, it's not applicable, but if you apply the 2001 directive, not the 2001 directive, sorry, if you apply the directive on public lending, on rental and lending, but through the intermediate step of considering that video games as images are protected by the common law copyright, the copyright of droit commun of the Directive 2001/29, then you should apply the public lending. And the decision was completely confusing because actually it had no guidance from the European Court of Justice on that issue. And I think that we should have a more consistent systems here. So it means that we should have the same exceptions for all, educational use for software. Why not? If you are in if you get an education in computer programming, why shouldn't you be able to use computer programs for illustration of your education? It makes sense too. Library preservation. You have museums of video games. Shouldn't those museums be able to preserve old video games that were made mostly with codes? Maybe there is also a public interest here. So I think that all exceptions should, as a principle, apply to computer software, to database. Even if it's no use, okay? You will not make a parody of a computer program, or it will not make laugh a lot of persons except computer scientists, I don't know. But whatever, if the exception is in the list, whether it will be irrelevant for computer software, it's not really a legal issue, I think. The private copy is, of course, another matter, and maybe it should not be applicable as it is now for computer software and database. And then the specific exceptions that we have in computer program directive and in the database directive, I think we should treat them differently. You might have some exception that could be expanded to all types of work. I think of a backup copy, of a decompilation copy. Maybe they will not be relevant for some types of works, but they might be relevant, for instance, for video games. You might think that you need a backup copy of your video games if your computer crashes, and it could be relevant to apply it to all parts of a video game, the computer part or the computer code part or the visual part of it. And then you have other exceptions. They were really tailor-made for database, for instance, or for software. But maybe you can transform them from an exception status to a non-infringement status. And I mean, for instance, the fact that you can use some insubstantial parts of a database where you are a lawful user of that database. For me, it's not an infringement. It should not be qualified as an exception. It should be qualified as not being an infringement to the sui generis right. The use for study in the software, for me, it's not an exception. It should be non-infringement because you just use you use the software to study its idea, its functioning, and it's out of copyright protection. So we should do something here to make it more consistent throughout all directives concerned with exception. Then the next step would be that, and this is where I would introduce some flexibility, and I actually concur with Thomas Dreier on that point. I think that we should define exceptions differently. We should start from the objective of the exception, from the function of the exceptions and the public interest or private interest that is pursued by these exceptions. For the moment, the exceptions are mostly defined by the permitted use, whether it is a reproduction, whether it is a communication to the public, by the beneficiary, and by specific conditions and limitation. And this does not create a lot of flexibility as uses evolve, even if different uses are required to pursue the same objective. If those uses were not concerned by the definition of an exception in the directive or in the national law, it will not be permitted. And actually, it is, again, I will use the example of libraries. The uses of library have changed in the last 20 years. But at the same time, they all pursue the same ends. They want to preserve the collection they have. They want to make it available to their patrons on the premises of the libraries. And yes, it's true, they want also to make it visible online. Okay? So I don't say that everything of that should be permitted under an exception, but I say that we should start by looking at what they really need and what is the public objective that the library pursue to try to define a sphere of exempted uses. Also, an issue that was mentioned by Martin yesterday was in the Technische Universität Darmstadt. This very limited view of exception by exception makes the Court of Justice sometimes create a new creature. I like the examples you gave, that saying, okay, the court says this is what a library should be able to do. And to do that, I will use, yes, the 5.3n exceptions, but I will add some dose of private copying, and then I will also remind that the exception for digitization could be added to make it consistent. Okay? We should not be forced to those types of tricks. We should have exceptions that are consistent with the use, the reasonable use that could be claimed by the beneficiaries of the exceptions. So actually, we should start from the needs of the beneficiaries, the objectives, whether they are private interest or public interest. The private copying, for me, meets a public private interest objective, not a public objective, but it's still valuable in the balance. We should also look at the practices of the beneficiaries. What do they do in practice? How do they work? And then we should add a measure of reasonableness, because I don't want that everything they want to do or everything they need to do be authorized by a copyright exception. That would be completely unreasonable. So we should find the sphere of uses that could be under an exceptions. We should have some criteria of no economic significance, no economic harm using the three-step test to measure that reasonableness and that limitation. And so we should have a sort of magic formula that says that uses in libraries that are justified by their public mission of preserving cultural heritage, for instance, and make it visible to the public could be justified to the extent that, and find more vague formula that really strict conditions. So this is how I think I diverge from Thomas' proposition in the way that I would not go into too much detail. I would add flexibility because the wording would be a bit more vague. And we have examples already in the acquis communautaire. For instance, the use for the illustration of teaching. In the directive, it is only the use for illustration of teaching. There is no other conditions than that. Then in the national law, you see a lot of different conditions, and this is where actually the mess comes, because you have countries that don't even authorize the communication to the public for the use for the illustration of teaching, and you have others that will limit some use to the classroom, or they will limit some use to a certain number of copies, and so the divergence is there. But if we keep a broad wording, maybe not so broad than that, but a broad wording with maybe some guidelines on the side, then we will have a sort of purpose defined exception that could evolve around time, and then the flexibility would be for the judge to address. The judge would have a certain margin of appreciation to be able to make the exception flexible and dynamic and answer new needs or new technical uses of works that would be justified by the purpose of the exceptions. And that would mean also that actually the mandatory character of the exception would be mandatory also for the objective. I mean by that if the objective is to ensure that use for teaching are permitted to some extent, to some reasonable extent, and with no economic harm to the authors, then it means also that you could not differentiate as national legislation whether you will admit e-learning or not. You have countries that don't allow use in online for educational purposes, but actually that does not comply with the objective of the directive, so it should not be allowed. I will speed up a bit. Another example, and I know that here I will be a bit more controversial, it's the example of the public lending. I think that the public lending, if you go back to the objective of public lending in the European legislation, but also in the practices of the libraries engaging in public lending, is the fact that in copyright you have different avenues to get access to works. You have the market. This is the regular way of getting access to a work. You buy a book. You have the second-hand market. You can buy a book, but this is a book that has been distributed already and that actually has been resold by another person. This is another way, a cheaper way, normally, to get access to a book. And then you have a sphere that is not mediated by the market. This is the private exchange between individuals, and there are the libraries. You can get access to books because you go to a library and you check out a book for 2 weeks, and then you read it, and then you come back with the book. That has always existed, and I think that for democratic reason it makes sense, because it gives access to a broader range of people than if only the market would intervene. Going digital, actually you lose that three ways of getting access to works. You still have the market, but we don't have the digital exhaustion, so we might not have it in the future. And then we would have no e-lending because we consider that it's not authorized under current copyright law. But then it means that all access to culture will be mediated by the market. And for democratic reasons, I don't agree with that position. I know that for e-lending, publishers says we can provide the libraries with the means to get access to books, so you don't need to get an exception because we can do the job, the market can do the job. Yes, but it will be the job done by the market. So it will mean that the packages of books that will be offered to the libraries for public lending will be the books decided by the publishers. It means that there might be some effect on the privacy on the patrons of libraries, and it has already been visible in the US engaging with e-lending by licensing. It has some effect of privacy because data of people borrowing books in libraries are transferred to Amazon in some case that make suggestions to the readers about the books they might like and they can buy by any chance on Amazon. So I think we have other stakes here than only the protection of copyright owners. And I think that we could devise a new exception for e-lending that would be justified by the same objective that we had for analog lending, and that could be adapted to digital possibilities and risk. It doesn't mean that public lending could just trump the market. People should still buy books online, but they could have also the possibility of checking out a book. So that would mean several types of conditions that would mean that the new volume of Millennium will not be available in all the libraries in the world online, and you don't even need to get to Amazon to buy the books, you know. So it means some definition and some frictions, but it should at least be also considered as an exception. Okay. I'm sorry, I take too much time. For the cross-border dimension, I will be very quick because a lot of people have talked about it. So we have these territoriality issues because of the territoriality of copyright. We don't have yet a clear case about the applicable law to copyright exceptions, but we have cases in jurisdiction question that might point out that actually the availability of content somewhere might justify that you comply with the law in that territory. So that would mean that actually offering something under an exception will be complicated if you want to offer it in different territories. Either if you distribute a tangible object, the Court of Justice in the Donner case said that the act of distribution might actually happen in several states. So that means that if you distribute an object that was manufactured legitimately under an exception, for instance, an adapted work for disabled people, then it would mean that this product needs to comply with exceptions in several member states. Online access is even more complicated because if you are offering education, e-learning across different member states, you need to comply with the exception for educational use in all those member states. So that makes your offer very complicated. So to solve that issue, there are several possibilities. The most radical one is, of course, to create a unitary European copyright. It will solve the issue, but we know that we are not there yet. The mandatory exception might be also a solution. It would actually accommodate the territoriality issues, but it would work only if the conditions of the exceptions are also harmonized and made mandatory, and not only the fact that you need to have an education exceptions, for instance. Then you might have another solution that is appearing in the Marrakesh Treaty that deals with that issue by saying that if an accessible format copy is made under a limitation of an exception in one country, that accessible format copy may be distributed or made available to a beneficiary person in another contracting party. It is possible because you have this intervention of the authorized entity in the Marrakesh Treaty, so persons authorized to make adapted copy for disabled persons. It might not be so easy to devise such a solution for other exceptions, but at least this is also something that could be followed to look if we can overcome the cross-border effects of exception. As to the fair compensation, I think that we need then to say if the exception is is with a fair compensation obligation. That obligation should be, you should identify a debtor for this obligation of fair compensation. So if you have, for instance, an e-learning programs with several universities in Europe, then they should decide among themselves who will be liable to pay the fair compensation, and then they organize the rest amongst themselves. You know, it happens every day for research programs across Europe. It could happen also for learning activities. So to conclude, it might sound as a recipe for something. So I don't know if I try to cook something, to make magic, and to find the alchemy of exceptions. And I don't know if what is missing is the secret ingredient or magic formula. I realize that what I threw to you is maybe a bit of a, you know, out of my hat, but not really realistic. I think that at least we have something that a lot of other speakers have touched upon that we try at least to start to turn in the chaudron, in the cauldron, to make it work. So thank you.
Thank you very much for excellent presentation. Are there any questions particular to Professor Dusollier, and then we will proceed to discussion part. So, anybody? Any questions? So then I would like to invite today's speakers to take a seat in front of us, and we will proceed with discussion part. It will take not longer at 45 minutes. So I think there were quite a lot of new perspectives which was brought in by today's speakers, both so in respect of relations between exceptions and limitations and contracts, between technical definition of economic rights and versus focus on exploitation of work, and also other aspects. So maybe there are questions to our today's speakers as to these new perspectives, or maybe we have any questions continuing discussion yesterday. So please.
So I just wanted to go back to a point that was raised by the last speaker, but I thought maybe was more across all the speakers, which was this concept of non-infringement and where that could fit into a scheme for exceptions, or perhaps be carved out of a scheme for exceptions but treated in some other way, and would be interested to hear a little more about how that could work. If this isn't part of the magic formula for exceptions, where would it go? Would there be another article listing all the non-infringement? Sort of a sub-question there just on terminology is, when you're saying non-infringement, is that the same thing as limitations, or is there something else that is limitations that would not fit within non-infringement? And part of the reason I'm asking that is obviously there's recent European case law where there's reference to limitations and exceptions, but where perhaps there's a view that it's not entirely clear what the differentiation is.
Okay, sorry, I thought that it was open. So I said that actually I didn't address that non-infringement issue by using the terminology of limitation, even if I think it could be a limitation. But for the moment, the term limitation is used in the list of Article 5, so it refer rather to cases where there is an infringement of exclusive rights, but that infringement is authorized by an exception. So, and I feel completely lost with the last decision of the Court of Justice about this distinction between exception and limitation. So yes, some clarification of terminology could be of some use. This is why I used the non-infringement, because I didn't want to enter in that distinction. But I think that, and it could be also non-infringement in different ways. For instance, the exception for computer program study is not an infringement because it concerns primarily the getting access to ideas that are not protected. So it's outside of the scope of subject matter for copyright. But for instance, if we refine the reproduction right in a way that actually the questions of temporary reproduction would not even be raised, because it will not be an act implying the reproduction right seen as something that has a link to exploitation, that it will not be an infringement of copyright because it's outside of the scope of exclusive rights. So there are different levels also of non-infringement of copyright. So I don't know if that answers your questions or it makes it more difficult. I don't know.
May I add maybe an element? In France, we are, we have been implementing the directive, and we are supposedly having a very high protective legislation. But so far, we used to consider that the reproduction right was only involved when, per se, the reproduction involved an act of communication to the public. So it was a little bit, for us, it was not really needed to implement the Article 5.1 because it was outside the scope of the usual and traditional definition of our reproduction right. We had to do that and to comply with the new scheme of the directive and the reproduction definition, which is broader than we used to have. But maybe, well, this is, linking the use of the copy of the material to the fact that there is indeed a communication to the public is really interesting way of thinking copyright, and would limit a lot the question of scope of the definition of the right and need for exception. And as regards infringement, you can also address, I know it's a little bit out of date, but between the commercial and non-commercial use of work, you can maybe distinguish between some elements that would would be infringing, but no criminal dimension of the infringement, whereas in some cases only civil damages and no criminal. Yeah, it's also maybe a way to. Do you want to add something?
Yeah, maybe actually that. Does the microphone work? Yes. There would have been the same question I was addressing to Séverine, because I was a little bit puzzled. If you have an act which is within the realm of an exclusive right, that act can by definition not be non-infringing unless you have a limitation and exception. On the other hand, if you do have an act that's on the realm that's covered by a limitation and exception, that cannot be infringing. So where's the difference between the two? According to my understanding, an act is non-infringing if either it is not covered by the exclusive right in the first place, or if for technical or whatever reasons the exclusive right is broader, so that actually we are in the realm of the exclusive right, it is covered by an exception and therefore exempt from liability and therefore non-infringing, which covers, in my opinion, another point that's never been raised in any jurisdiction, and that's the burden of proof. If theoretically you are with me by saying that limitations and exceptions are limitations defining the scope of the right rather than exceptions, which are the exception to the rule, then what does that mean for the burden of proof? Technically, plaintiff has to prove that the defendant engaged in an act which was on the ground, within the realm, within the scope of the exclusive right. Now that could, I'm not saying would or need to, but could also imply that it's up to plaintiff to prove that no exception takes place or comes into play. But that, however, to my knowledge, the courts do not go along with. So in a way, they always have, from the burden of proof point of view, always treated limitations and exceptions as true exceptions and not as limitations. Maybe that has to do with the fact that if you have the burden of proof in the other way, then it amounts to the proof of something, of a negative fact. And that might be more difficult, but yet, I mean, we have to think it through. And that's, I think, for practical purposes, that's what's behind it, because depending on what you can prove, the outcome of the case might be decided. And as long as you have a broad, far-reaching reproduction right, of course, that's easily being demonstrated. In each digital device, there's a reductionized period. Up to you to prove that you are on the ground of that you can invoke some limitation and exception. And that might be pretty difficult, because all the uncertainties of how far the exception goes, where the limits are then placed necessarily on the defendant, and the plaintiff is off the hook in this respect.
Just to say that the point is that at the moment, to my understanding, the Court of Justice distinction between exceptions and limitation goes away. The opposite. I mean, they said limitation is just in the realm, in the scope of, but just limit the use, whereas the exception is really outside the scope, more or less. So it does not match with what we would consider that limitation as an external boundary of the exclusive right. So we definitely need clarification on this.
First, a comment following the intervention of Michel Woods and your response on maybe the distinction between the issue of exceptions and the issue of infringement. I think there are two different things, and sometimes we forget that there is as well the last step in the analysis of a copyright infringement case. It is whether the test for infringement is met or not. And some of the elements of your recipe for, the new system, like the measure of reasonableness or the spoons of no economic harm, they might intervene as well in the test for infringement, which is the last part of a standard copyright case, when, for instance, an exception does not apply. We should not forget that there is this last, I think, level, and when you are discussing in the terms of no infringement, it might refer either to the application of the exceptions or the analysis of what is an infringement, where the de minimis rule, for instance, can intervene, because judges there tend to apply some kind of reasonable tests in the analysis of the infringement. I think it's another question. We have to understand what should be under the exceptions and limitations, and I don't think we should distinguish the two because it covers the same, but that's a view. And what should maybe left to the judge in the analysis of the infringement itself, which is something which is a black box, I think, in Europe. There is not much. When you look at copyright treaties, there is not much on that, and it's just the opposite in the US, where you have a very deep analysis of what is an infringement, and even if a use does not apply, you still have to analyze and go into details, and there you have a lot of principles. So that's one comment. The other one is the relation between exceptions and contracts, and I think, you wanted to have a uniform system between the exceptions for database and software on one side and for other works, the InfoSoc Directive on the other side. Yes, it's important because the status of the exceptions is different. They are not waivable for software database. They are waivable for the rest. I had there a question. I don't remember who mentioned that. I think it was Thomas. In the UK, you have a lot of exceptions that you can waive by contract. In Belgium, we just have, in principle, the opposite. All the exceptions are unwaivable. Now, I don't know whether we analyze now the functioning of the two systems, UK and Belgium. In principle, it should go in completely different directions. it would be interesting to have such a comparison. I don't know whether you have a view or say on that, but basically we have two opposite situations and no harmonization so at all there concerning the status of the exception, but does it raise real problems between the UK and Belgium? Okay, question.
I should make clear that actually when I say non-infringement, I don't mean that suddenly I would create a new category. You would have, non-infringement cases, then limitations cases, then exceptions cases. I didn't mean that. I mean that actually if we define better the scope of exclusive rights, those uses that we are obliged now to cover under an exception will not even appear in the list anymore, and in any list. Like Valerie-Laure explained for French law, the temporary reproduction was not at all in the French law before the transposition of the directive of 2001 because there was no need. It was not covered by reproduction right. So I don't mean that I would create a new category. I just mean that this category will just get out of the copyright legislation because implicitly they will not be covered by exclusive rights, and that might be explained in a recital, in a guidelines, I don't know, but it would not be a new provision, that would say that is not an infringement. This is the way I was looking at it. As to the interface with contract, I didn't touch upon it because I knew that Thomas and Valerie-Laure would have done it, but I know this is a very complex issue, and we have completely different legal traditions. I'm not sure that the Belgian, I wouldn't say tradition, but I would say choice is the most reasonable one. I don't think that all exceptions should be unwaivable by contract. I think that we should distinguish in some way. But I think that in some cases where the public interest is involved, licenses, for me, the market cannot offer everything. There might be some sphere where actually the copyright owners don't intervene and don't pose some conditions. You would not imagine that parody would be subject to licensing. For me, it would be completely strange to have a parody, under a licensing scheme. But
maybe the difficulty is that somehow the contracts are sometimes written in such a way that they don't provide you for the exception, but for all the acts that are necessary to have the exception. And so this is if you have this impediment through the contract to get access to the material, then how do you enforce your exception? You cannot do that. And even if the contract has not for the subject the exercise of the exception per se, because it would be meaningless according to me, you have possibility to circumvent this impossibility to contract the exception throughout different elements, like having access to the work in some format which would be compatible with your devices and so on. So there are lots and lots of things to address in order, if you really want to overcome the limitation made through the contract, in order to enforce the use made allowed by the exception, then you have to go deep in tons of contracts that are surrounding the business model of the right holders and all the platforms and whatever.
Maybe the problem could be solved in a more general way by not looking into the interrelationship between each individual contract and each individual limitation, because in my opinion, the fundamental issue is who retains the public power, the public policy power to decide whether contracts or whether exceptions prevail. And I think your example you gave is a perfect one. In this respect, the Belgian state and the UK state, they both want to retain that power to decide on the effects of the relationship between contracts and exceptions. So if we go a level higher and look at the EU level, the question would then be, under what circumstances should that power be taken away from the member states and should be vested at the EU level. And again, we could have some sort of something similar to this split with regard to contents, which questions, which limitations and exceptions should be regulated on the EU level and which could be left to the member states. So maybe you could apply the same model to this question of overlap as such by saying for certain exceptions, this question shall be solved on the EU level, and for the rest, it's just left to member states. So that seems to be the point according to which that's a perspective according to which we have to analyze that problem. And it would probably make Maria's life much easier, because then she wouldn't have to go for an all or nothing approach on the EU level, but could kind of find a solution with regard to the contract exception overlap for particular exceptions. And for example, say the citation right can never be signed away, parody right can never be signed away, or by individual contract only or whatever, and leave the rest to the others and not disturb established national practices.
If I may add also, you have some beneficiaries of exceptions that are willing actually to have licensing because it makes the modalities of the exception. It might not take away from them the exception, but it would make the modalities of exception clearer. So in some cases, for instance, libraries sometimes are very happy with licensing conditions, for instance, around TPM also, to define the conditions under which a non-protected copy of a work will be made available to the library. So we should not be naive and think that the users will not be happy with licenses. Sometimes they will be happy with licenses because it makes their benefit of the exceptions easier. So a complete prohibition of contract, I think, would be unreasonable too in that respect.
Okay, Maria now, then colleague from Austria, and Martin.
I had a question with Séverine. It's rather testing whether your magic potion works or not. And as many of those things, then when you get into the details, it gets a bit more complex. But you would say, okay, let's identify a number of exceptions and limitations, which, by the way, in my world, they mean the same, even if the Court of Justice has been trying to tell us otherwise, but no one understands. But take the exception for the purposes of illustration for teaching. As regards the cross-border effect, you described different techniques to get there, and I think those are the techniques that exist. Obviously, some of them are more complicated than others, like the one of defining the making available right on the basis of the country of origin, because that hits well beyond exceptions. But let's forget that. Let's assume that we have solved that one and say, okay, define it for the purposes. So the purpose is illustration for teaching, unless you wanted to go wider and say the purpose is education in general. And you are saying, okay, we make it mandatory. We make sure that it's mandatory in terms of being an exception for the reproduction, the communication to the public. That includes as well, for instance, the issue of public performance in classrooms that you were referring to, and making available. And then there are your two spoons of reasonableness, which is when we get into difficulties, because at that point the EU legislator is in front of, where do I go? Do I go the way what I say, provided that it is not, and we have that type of elements already in the exception. It is justified by the non-commercial purpose to be achieved. It's not to the prejudice of, I mean, you could think of things that will very often come back to part of the three-step test, and you leave it there, or you go into much more detail. If you take the first road, will that prevent member states to say, when implementing, I think that in compliance with my obligation under the directive, for instance, I can exempt textbooks from the application of the exception. I mean, that is the level where we're going to have decisions at some points in the discussion, and that's where I would like to see if your magic formula works.
Yeah, so this is because of that type of complexity that actually I'm not considering myself as the witch in the last slide. Maybe you will be the witch turning in the cauldron, I don't know. But I don't want to take that role. No, it's true that it's more complex than I pretend it to be. And the use for illustration of teaching is a good example, because for the moment it's a very broad exception in the legislation. I think that it's not used for education, it's used for illustration of education. So there is this illustration element that is very important. So you cannot just use works to make your classes funnier or nicer. You cannot put protected works on your slide during the class just because it will just make your students more attentive to what you say. No, there should be a relationship between the works you use and the topic you teach. There should be something, a link at least. So this is the first element that is make it reasonable. Then in most countries that have introduced the use for teaching also in an online environment, it is limited to registered students to the course. And this seems reasonable too, because it's a use for illustration of the teaching to a specific class. But then you have the development of the MOOC. And so if you want to make a MOOC about the art history of the 20th century, you will need to show some paintings. Or you make a MOOC about musicology and jazz music. You will want to just make some pieces of music available to the students. But when you have a MOOC, when you have 10,000 students scattered around the world listening to your or following your class, that makes it a bit unreasonable, So what would be the proper test to just say, okay, here you have 10,000 people registered in your class, but actually your class becomes a way of getting access to jazz music for free. That would be completely unreasonable. So maybe you might have other elements like saying, okay, you can play 30 seconds of a music to show something that is relevant for what you are teaching, or you can show some paintings, but it will be in a streaming mode and it will not be, available at all times. I don't know. So that will be the margin of flexibility that maybe make that if someone is claiming that it is within the sphere of an exception, it has to prove that it doesn't go too far, and the judge could think case by case that it goes too far and it should not benefit from the exception. Then you might go a step further and have the guidelines we mentioned yesterday, with some example of reasonable practices and unreasonable practices. I don't know. I know that if you want to cover everything, you will need to have a very detailed exception, and my systems will not work. I think we need to have vague formulas, but with some tests, in guidelines or not, and then trust the judge to have a case-by-case analysis to see whether it is reasonable or not. But this is already the situation. We are, as academics, we are in university, and all of us, I suppose, have already received requests from our own university saying, hey, we are doing that project. Can we do it for copyright reasons? And even if our law has a very detailed exception, we are just struggling with the vagueness of some elements of it, and we say, hey, there is a risk, there is that, and we just try to make a risk analysis and say to our university, you can go, or you shouldn't go, or this is the risk that you are taking. So I think the situation is already, despite this detail in the legislation, it's already very vague and difficult.
But there will be, there is the fundamental difference, which is the new situation will say to all of the member states, trust the judge in country X, and he's going to determine the extent of the use of a work under an exception for the purposes of teaching, in this example, including a cross-border affecting other member states. That's the big difference. That's where is the cross-border effect that is going to require finding a solution to getting trust to. It's going to lead to the fact that the interpretation of the margin of maneuver of what it is right or wrong undertaken by a member state is going to have an effect in all of the other member states.
Yeah.
That presupposes that you work on a model where the decision of one member state necessarily has effect in another one. Because my understanding was, if we do have an exception which allows for flexibility, and the judge in your country, Spain, says, well, we interpreted this rather broadly, German judges would not be barred from interpreting it more narrowly on the very same facts.
We're talking about cross-border effects.
Yes.
Yeah.
Yeah, but still.
No. University X in Spain will have an interpretation backed by the judges as to the extent of the exception for the purposes of teaching, and will be under that exception also providing services across border to students in France, in Belgium, and in Germany.
And the German judge would say that is overstepping the test of reasonableness, we don't allow it, and then the Spanish guy would either have to carve out, Spanish university, would have to carve out Germany as a territory, or take the material out, or license it.
No, the Spanish...
That would be, that's only the starting point.
No,
if there's disagreement, you could go to the Court of Justice, or the legislator could regulate the matter, if it then was of imperial importance.
No, Thomas, because there will be a cross-border effect. If, for instance, with one of the techniques that were described by Séverine, which has along something like the legal fiction undertaken in the Marrakech Treaty, Article 5, then, the Spanish judge will say to the German judge, none of your business. Have a look at Article 157 of the new directive, and there you will find how I have the backing of the legitimacy of what I'm doing.
Yeah. That's exactly what I'm saying. If you rely on some mechanism such as in the Marrakech Treaty, you're absolutely right. But as long as we don't have that mechanism in general, and so far, to my knowledge, we only have it in the Orphan Rights Directive and not in others.
Yeah, but if we're not going to have that, why are we doing this?
The
purpose here is to allow for the exceptions as well to function in the cross-border environment.
You would base on mutual recognition of legislation, like the Cassis de Dijon case, absolutely. Well, the level of requirement supposedly is the same in different countries, and if you match the requirement in the country where the content has been pushed, then it would worse for every country. So this is Cassis de Dijon basis case law.
Yeah, I think that one side effect of that, because we need to overcome the cross-border effect, so I would not be in favor of the status quo. So it means that yes, a decision by a Spanish judge can have effect in other territories, because at some point you would decide that the assessing of the legitimacy of the exception will take place in only one territory, be it the territory of the infringing act. Like in the Eshduk case in January, it seems that at least the state where the provider of the service has its establishment would be used as a criterion to judge where the infringing act, the causal event, takes place. And it could be that criterion, and it's true that the side effect would be that maybe the most lenient conditions for the exception, as said by the legislation, but fortunately we can hope that at least it will be harmonized, but by the judge, maybe the Spanish judge will be more generous in the application of the exceptions than the German judge. And yes, you might have a fragmentation there, but then we need to work for more harmonization also on that level with the control of the European Court of Justice. I don't know, but I realize that it is an issue, but we have fragmentation now in any case. So saying that the fragmentation will only be displaced with different practices of the judge, for me, yes, it's a risk, but I also trust the judge to try to collaborate and try to achieve similar results by enhancing collaboration also amongst judges. But I know that because we don't have in most countries copyright specialized judge, we are not in that direction. I know the practical difficulties of what I'm proposing. But
question back to you, Maria. In our hypothetical example, what about if the German court is seized first and comes out with the restrictive thing? Would that also have cross-border effect and then bar the Spanish judge from getting any further? Because I think we're not quite clear on what we are talking. I mean, what the basic level is, what kind of transborder effect model we think about.
I think, part of the discussion of the discussion we are having now, and I'm going to stay only with limitations and exceptions, not getting into cross-border licensing, and let's even stay outside infringements, because I don't think it's relevant, is trying to find out for users that have a potential cross-border effect, and you could think of such users related to education, to research, to libraries, how do you provide legal certainty so such cross-border acts can take place under an exception? We had that in the Orphan Works Directive, and we did provide for a solution in the Orphan Works Directive. If the Union was to intervene now in the area of exceptions and limitations, or some of them, it will have to look into that. And the ultimate goal of my question is, which is the real problem, is how much harmonization you need, how much of common rules you need in order to be comfortable with the cross-border effect. Of course, there is always going to be a judge that is going to be interpreting whether something is not with or without the remit of the exemption, but it's just how comfortable can we be by giving a very open formulation, that's what I was referring to as part of your presentation, that this will be enough, because you might have a university in France that is told you cannot use for your online courses this type of material because we consider it to be outside of the exception. That's more restrictive, but you may have them, but it is a German or any other judge that will say, yes, you can use them, and little matters whether your students are in France, because we will be providing cross-border effect to this exception. So I don't think the question is whether we have or not to provide cross-border effect. If the Union is going to intervene, in all likelihood, it has to look into that. The real question is how much harmonization is necessary and is realistic to achieve, because I can see the problem of trying to fix the details at European level as well.
I would go for a maximum harmonization for those issues. So maybe the vague wording of the exception wouldn't fit with the cross-border effect, but maybe you can combine a complete harmonization of the exception for cross-border users and make the margin of maneuver as a system of equivalent, saying that, well, maybe some restriction decided in each country would have an equivalent effect. So you would, in that perspective, say that there is a kind of similarity, even though the way the directive is being applied in each country is varying a little bit. But the drawback is that we have a directive and we don't have a regulation. So that is the margin of maneuver of the member states as regards the instrument, which is a directive, which is they are supposedly free to choose the way to achieve the goal of the directive. So that is the problem. So either you have a wording of the exception, the provision that is similar to the one of a regulation, and there's no room of maneuver ever for the member states in defining the exception, and you have only the margin of maneuver of the national judge, but according to the wording of the exceptions defined in the directive, or you open a little bit of freedom at the stage of the member states, but you cover it through this system of equivalent or of mutual recognition, saying that on the average those and those use are supposedly being equivalent and recognizable in either country. I don't know.
There are some more questions from the floor, if I may then.
Thank you. Just a short question. I'd like to stress what the last speaker had said, that we will have to identify the one who is going to pay the fair remuneration. I think that's absolutely right, because what we can see, I think, is a shift from exclusivity into fair remuneration in the online content, because I think right holders start to realize that the exclusivity might not be the appropriate tool to control their rights in the online world, and they would rather take a fair remuneration, be it that you grant the fair remuneration through an exception or through a statutory license, which would be another way of giving them a proportionate share of the income. And here comes my question to Valerie. As I understood you, if I understood you correctly, you would suggest some kind of consumer contract clause for the platform, so that they can be the ones to license the user-generated content. And I'm wondering, why can't you just make an exception or limitation and define the one that exploits the content economically to pay the remuneration? Why can't you just say you have an exceptional limitation But I think legally it's not impossible. It's like some kind of, we would say, Verwendungsanspruch, some kind of enrichment. The platform exploits it. It gets money. It gets us money from the advertising because it uses the content, and it should pay a proportionate share of it. I think it's feasible.
Yeah, but actually, either you think that the platform does make an act of which is part of the copyright rules, and then it's you have a problem with the e-commerce directive because they advocate that they are not displaying, and the Court of Justice and the national courts are considering that the platforms are not communicate the content to the public. So here you have this problem of how do you imply the intermediaries in the commercial circuit. Either you take a step aside and say, well, it's not part of the copyright rules anymore, and we draw a specific system, which is the fact that someone who exploits a work but is not communicated to the public might pay a remuneration for that. But my concern is that it's very complicated to make a distinction between communication to the public reproduction and exploitation of the work first, and then what would remain of the copyright system if you do that. I wish we could do that, but I've been assessing those issues for the French report of the CSPLA, and so far they did not succeed. All the proposals of enrichissement sans cause and so on that were on the table did not succeed. So what would be the ground? So you have to create a new neighboring right for exploitation. Germany has tried. It was a failure, so I don't know.
Well, I'm not sure. Don't we have already a precedent, like the levy for private copies, to be paid by the importers? Importers don't make private copies. So, okay.
There's no such a thing as a private communication to the public.
Well, okay, no, I'm not arguing on a private line of private communication. I'm saying just as a legal model. Apart from the fact that we are you actually aware of it? We are working on the terms of reproduction, communication to the public. Now that's the Gutenberg age, and that's the radio and broadcasting age. We're in the times of the digital. Who makes money out of the new digital technology? That's the ISPs. And the ISPs are not even mentioned in our system. We create a system around the major players. Seems to me somewhat anomalous to me.
The last question.
I'll try to be short. Just while we have the benefit of academia with us, and I know that I like the idea of talking about going back to the purpose for which we're using copyright and whether exceptions or limitations should apply. Text and data mining was mentioned as an issue, I think, by a lot of the people that I've heard here today. And I just wonder, I know you talk about living in an ideal world and with ideals, but I know that you also live in the real world, and that in Europe we have a whole body of researchers. And I think maybe just for the audience, it might be useful for us to hear a little bit. What are the impediments? What are we losing at the moment from the point of view, let's say, that in Europe we don't have an exception that allows for text and data mining? Just maybe at a practical level in universities, how are we impacting our EU researchers versus those that are operating in markets outside of the EU?
I couldn't probably tell you about the situation in the US, but in Germany the common debate between users and publishers has been that, first of all, the technology people could not tell us to what extent there is reproduction. Some technology guys came and said, well, you can do text and data mining without acts of reproduction. Now, I haven't the faintest clue whether their idea of what a reproduction is the same that we have in copyright. That's first point. Second point was that there was so much insecurity about the potential of text and data mining. On the one hand, its economic effect, and the question of how far it should go without payment, with payment, under what conditions, that the idea in Germany was, and I think I mentioned it in my talk, to just start the whole process on a trial and error basis with time-limited contracts between the major players. So let them find out first where their real interests are, because publishers don't really know what the market potential is and the real value of their aggregated knowledge and databases with regard to text and data mining. The text and data mining people don't know what the use value is, how much it is commercially valuable, what they get out of it, or whether it should be left in order to foster research and innovation, whether it should be made completely free, such as we have made the human genome free and taken it out of commerce. So probably before that would be my guess, before the legislator intervenes in the lengthy process and writes down an exception which sits on the book for another 15 years, let's start with private practice, and if something goes wrong, then the legislator might intervene. But that's also a shot into the dark, I must admit.
So as I'm aware, we have, I think, 2 more questions from the floor. Silke, please. Yes.
Okay, thank you. Well, there would be many comments or questions. I just want to pick out very few. I think we don't need to reinvent the wheel. Thomas, you said something about this opening clause with comparable cases. Don't we have a similar thing by the simple old technique of analogy to be applied under certain conditions? So I think there have been already solutions on the basis of application of analogy. I'm not sure whether it would be really good to open it up more, all the more since there's a question who would say, well, the judge would probably say what is comparable, but from which point of view? From the user's point of view, from the economic point of view, from the, there might be different ways of saying what is comparable, which 2 situations, in which way, according to which criteria. Then on your chart on recital 9, so to say, well, that's also kind of open, because one could say, well, the high level of protection, which is in recital 9, that's exactly the point where your graph was up there. So it doesn't really help, in my mind, further to know what is high or what is. Directive doesn't say the highest level possible, which would probably be the downside. And also, you talked about function. There are different views about what is the function of copyright protection. Some say, in the Anglo-Saxon system, it's to encourage creativity. In the German and other continental laws, you have rather the principle. It's covered. It's a reward for contributing to cultural diversity. It's a matter of principle of property right that first, I know many people don't like to hear that, but it's a fact of law. So it's a principle. You shouldn't diminish this principle by the function, which is not uniformly determined. Reasonableness, I think that's already somehow in this three-step test. We have it. I don't think you have to reinvent that in different terms. Yeah, well, I keep it like this because we have not too much time.
Just to answer what is the copyright for? It's a very difficult issue, but do we think that when we say what is copyright intended for, do we only think what exclusive right is intended for, or what the system of copyright is intended for? Because cultural diversity, for example, you can achieve that through exclusive right, but also through exceptions. So, you know, I don't think that never in the history of copyright there was only the exclusive right and no balance in the system. So, well, it's just...
No, I didn't say that. There shouldn't any... Of course, there was always balance, but I just want to say that what is the function is... There are different views on it, and
sure. No, you're absolutely right. It's two tales of copyright, and we will not get agreement on this here. You have heard both stories presented in a hopefully brilliant way, so it's up to you to make your mind. That's all we can say. The arguments have been on the table.
First of all, I want to thank you, Thomas, for mentioning the role of ISPs, because I believe that they are the beneficiaries of the largest, biggest exception in the history of solar system planetary copyright. I don't see any good reason not to also take into serious consideration that also the e-commerce directive should be revised, and not only the copyright directive. First point, because I believe that the money are there, and authors and copyright exploiters do need money. Second, I think that it would be important to take into serious consideration also the three prongs of the three-step test, and in particular the second, the normal exploitation of the work. And there, I think, lies the distinction in between contractual solutions vis-a-vis exceptions and limitation, the role of the market vis-a-vis the role of the state or public entities. As the debate demonstrates, it is quite difficult to find the right balance. And probably an easier way to solve problems is to double-check what the market has been able to do on a multi-jurisdictional, multi-territorial level. And there, where the market is not already present with viable solutions, which are not those who are more favorable necessarily to the beneficiary of the exception. Otherwise, you skip over the second criterion of the three-step test. The normal exploitation of the work is there. I'm sorry, it is beautiful to talk about free access, easy access, but works of authorship are very expensive and authors must be remunerated. So I wonder whether taking into a better consideration the step 2 of the three-step step would ease the analysis.
Well, I think that's an absolutely correct argument. The only problem I see with normal exploitation is that it's somehow circular or question begging. It's a normal market if there's no exception, and if there is an exception, it's not part of the normal market. So we have to find some way to break out of that kind of circular argumentation, and one way would be to trust the market first and then correct ex post, which is, in my view, the extreme weakness of limitations and exceptions, because they're always, or in most cases, they are ex ante projections on what the market might look without that limitation and exception, and they are generalized, so they don't take into consideration particular features that the parties in the markets would know better. So that would, summing up, would speak indeed for let's wait for some period and then intervene with an exception rather than having the exception in the first place. Now you could say, well, how long do we have to wait? Is the 15 years, is 2001 the starting point? Then 15 years is a rather long wait. Lots of things have been done. You mentioned e-commerce. I mean, remember, e-commerce, the exceptions were designed to protect this fragile new upstart industries that should not be suffocated by too much a burden of a liability. I'm just saying this. 15 years later, the world looks rather different. Now, was that waiting long enough? Probably yes. Fragile in the beginning, yeah. Those little plants that had to be protected against the right holders who would... Of course.
Thank you very much. Our time is actually ran out. So I would like also to thank Intangible Forum, to all our speakers for great presentations and views shared during discussion. Please. Thank you very much. So also objects of protected by copyright design. And so just some housekeeping issues. We have lunch served just across the corridor here at the EU House, and afterwards those who are members of working party of the on copyright of Council's working party are invited to meet up and have informal working party meeting, not in this room but on the ground floor. And outside there is another entrance, actually, just next to the entrance you use today. But it will help to find it. And just in the very end, I would like to thanks to all the speakers who have spoken today and yesterday for really outstanding presentations and for very valuable contributions during discussion sessions. And also for you all, for participants, and also for our online viewers, for attention paid and for raising interesting questions. And I hope this will be of use, these discussions will be of use for further deliberations on copyright future in the European Union. And maybe will give some impacts outside Europe as well. So, and I wish you to have a very nice weekend. For those who have to travel back home, safe trip home. Thank you very much.